All right, look, this is the Zoom tutorial for topic 2 on the real estate agent, and we haven't had anyone turn up. Two apologies I have to quickly add from 2 students, and that's great to have that advance notice. Look, there's only 4 students in the course, and so if a couple drop out, then there's not much. And I don't think actually that last week we had 2, and so if those students drop out, then we probably won't have any. But look, the point is, and I'm not going to. I'll do a short recording just for the benefit and uploading to Moodle website. I've done a presentation through Echo 360 for this topic, and hopefully it should be uploaded, in the next few days. That's my aim. There have been a few issues with uploading off campus, but hopefully that will occur. I've already uploaded a couple of segments from topic 1, presentations on Echo 360. Look, the 2 problem questions dealing with the agent tonight, and I don't want to go through the topic because I've done that in the Echo 360 presentation, but the 2 problems are focusing on, firstly, the process of appointing an agent in terms of a land transaction and a conveyance in Queensland. That's problem 1 on page 41 of your notes. And then problem 2, is focusing on this the thorny issue of the deposit. And I've actually asked you to look at a contrast between where the agent is acting as stakeholder on the one hand and the solicitor is acting as stakeholder on the other, and to advise a client as to which of those 2 are best placed to hold the deposit. So if we just go back to the first problem in terms of appointment, this is an important idea and theme because it links to the capacity that the agent has. It also links to the regulatory context of that process under the state-based legislation. And look, in answering questions on this topic, you do need to refer to the current legal framework, which is PAMDA, the Property Agents and Motor Dealers Act 2000, Queensland. But I certainly want you to be aware of the new Property Occupations Act 2014, still unproclaimed, as I've mentioned on the course website and also in the presentation on Echo 360. But, that's in terms of reform. So some, compare and contrast is probably the way to go. Basically, what I'm looking for here is just, a discussion of, what the appointment process involves and how that is regulated under the legislation. You'll see this is covered, for example, starting on page 23 of the notes, and the relevant provisions under PAMDA for appointment of a real estate agent is sections 133 to 137. And I point this out in the Echo 360 presentation that under the POA 2014, that appointment of property agents and resident letting agents, and there's 2 categories there under the new legislation, is dealt with under Part 4, essentially sections 102 to 114 of the new Act. And, so you can see the different ways in which the new legislation has dealt with this issue, maybe in a slightly different capacity to the old Act. The other point to just bear out is that I mentioned the point about regulation and accountability. Section 154 of PAMDA also sets up a code of conduct for real estate agents pursuant to the 2001 regulation. So just have an awareness of that. I mean, that's about, sort of the idea of setting, proper standards of how agents should be conducting themselves as appointed as agents in terms of a land transaction. The other thing, of course, too, is to be aware that the whole strategy of this regulatory arrangement is to license the agent so that you're dealing with properly regulated and licensed agents in terms of those that have the capacity and the capability to act on behalf of parties in a land transaction. That's the point. There's also, under the legislation, approved form for how this is to take place, and also importantly, under Section 135 of PAMDA, that agents are not there to give legal advice. I mean, that might seem a bit self-evident, but the truth of the matter is that the contract of sale is often sitting there on the desk of the agent, and a client might start to ask questions about the document, and it's really important that everyone involved understands that the agent cannot give legal advice on this legal document and on this important definitional structure of the transaction, that is the contract of sale. And I mean, that's irrespective of whether we're talking about a contract that merely has the standard terms or has additional terms. Many contracts, of course, have additional terms, but it may only have the standard terms and with the blanks from the form filled in, or the blanks from the contract filled in. But even then, it is not a case for the agent to think that they have the capability, nor for clients to, or those who agents are representing, mostly sellers, taking the view that they can ask the agent for legal advice in relation to the contract of sale. So the problem one asks you to think about not just that, but looks at the situation of the effectiveness of the appointment of an agent under Queensland law in relation to an agent's activities, which are both inside and outside Queensland. I mean, this is really tossing up the scenario a bit. It's a bit of a variation on the theme, but it's tossing up the scenario that was presented in Sultana Investments and Cellcom number 1, which is a 2009 Queensland decision. And in that case, and this is discussed on page 57 to 58 of your textbook in chapter 2, in that case, basically, you had an agent outside of Queensland acting in relation to a sale of property in Queensland. You had clients or parties outside of Queensland being flown up or ferried up to Queensland for the purposes of the transaction. The point of the case was where that agent is appointed outside of the jurisdiction and the sale is taking place in Queensland and it's about property in Queensland, should the agent be licensed according to Queensland law, which of course currently would mean according to the requirements of PAMDA, and hold a real estate license according to the Queensland legislative and regulatory framework. The court came to the view that this probably was the case. Although a person does not engage in negotiations, arrange for contracts to be signed or handle any deposits, they may still be acting as a real estate agent. Okay, and the case, as pointed out there on page 57, in Sultana, the agent, as I indicated, conducted his business in that way. On the issue of whether the agent could claim reward, it was held that the agent had acted as an agent in Queensland and required a licence in Queensland to be able to recover commission for service. So remuneration through commission could only be possible if the agent was appropriately licensed in Queensland. It would be the equivalent for a lawyer, a solicitor, acting on a matter in Queensland would need to have recognition in the jurisdiction or, as appropriate, for the purposes of facilitating the transaction there. But we're talking, more specifically about agents here. And, the whole purpose of this topic in this course, yes, it documents, the role of the agent. It documents the responsibilities of the agent, new legislation affecting that. But really, its purpose here is because of the relationship and the dealings that solicitors have with agents as a part of the facilitation of the land contract. And it's useful, important to be aware of the regime under which they operate, and how they function, and what they can and can't do, and the licensing arrangements, and how this is changing a little bit under the new legislation, and that we will have new legislation hopefully legally effective in the near future. So that's really what I was trying to get you to think about in terms of problem 1. Problem 2, on the other hand, is focusing on this idea of the deposit. Now, of course, the deposit is pretty central to the seriousness of the buyer in terms of the purchase of land, and requirements under the contract with respect to deposit. Queensland, unlike New South Wales, doesn't actually require a specific amount of deposit on the standard form contract. But the question is really focusing on this idea of the agent acting as stakeholder on the one hand, or solicitor acting as stakeholder on the other, and who is best placed, and who and how, what advice might you provide to a client as to who is best placed. Okay, this is taking you back to the discussion starting on around page 35 of the notes, and about page 78 of your textbook. But the point here is that what does this capacity of stakeholder actually mean? So that where we see that the agent is acting in the capacity of stakeholder, then we have to appreciate what the significance of that is. And basically, this idea of being a stakeholder is the stake in the transaction, and is there a requisite legal obligation with respect to the payment of that deposit, and at what point, where the person holding it, either agent or solicitor, is doing so in the context of being a stakeholder. Now, you will see this discussion starting, as I mentioned earlier, on about page 78, but more particularly on page 80 of chapter 2 of your text. In the problem question, I've given you a few cases there to reflect upon, and they're discussed in those pages 80 and following of chapter 2. And basically, the point here is that the issue that arises is where the agent is as operating as stakeholder. Can the agent exercise a lien over the deposit in a trust account? And this has actually, raised some different perspectives. And the cases that are referred to there are the Tibmore case and the Nickelbury case and the Active Property Marketing Services decision, and these in New South Wales, in Queensland. So these are, cases drawn from those jurisdictions. So in Tibmore, for example, the judge assumed that this was the case, that they could exercise the lien. However, Young in Nickelbury, which is New South Wales decision, took the view that no security lien for the benefit of the agent could arise whilst the money was held in a trust account for the benefit of the client. Inactive Property Marketing, which is a 2007 Queensland decision, the agent claimed a declaration that money being held in its trust account be applied to the payment of the commission. And the interesting point that's made here is taken an analysis of the judgment of Justice Wilson, that if the agent were entitled to a lien over trust money, then the agent could only be entitled to a lien over money belonging to the principal and not money still held as a stake, which might be capable of legally being the property of either of the parties at the time the lien was being asserted. Okay, so the writers, the text writers, go on to comment a bit further down the page on page 80. The question is whether the appointment of the agent gives merely a contractual right to commission and a remedy in damages for the non-payment of commission when due, or whether it establishes some right in the seller to a lien to the extent of the commission. So it's really, this turns on this point about the nature of the appointment. And again, the idea of that appointment under the POA, not yet legally effective, may be that the circumstances are clearer for us. But certainly under the current law, we're not absolutely certain about this, but there is issues here that touch upon that appointment process, and the nature, is it merely a contractual right, or is it something different to that? And then where is this money linked to, and so on. So that's there's some debate there, if you like, about how we understand the deposit in the hands of the agent as a stakeholder. On the other hand, we can look at the deposit that's held by the solicitor as a stakeholder, and the point here to remember or to bear in mind is that where the solicitor is holding the deposit as a stakeholder, then it will actually go into the firm's trust account. But this is the important bit, that those monies, those deposit monies that are in the trust account, are not governed, or the solicitor's duties and obligations with respect to those monies are not governed by the Trust Accounts Act 1973. They're actually governed on the solicitor's duties and so forth with respect to the deposit and how it is to be dealt with, are governed by the Legal Profession Act. For example, Section 2371, as I point out on page 37 of the notes, deems those monies to be paid to the solicitor in connection with the provision of legal services in practice. So there's a deeming provision within the Legal Profession Act with regard to deposit monies on a contract of sale lodged with the solicitor as stakeholder, and which then find their way into the solicitor's trust account. Now, in terms of the problem question, suggesting which is preferable and what might you advise your client, well, I mean, as a solicitor, you might well say, look, the money's better with me and in my trust account than it is with an agent. Okay. It certainly seems that there are some conflicting views about how the monies are held by the agent in that capacity and what the agent can do with respect to those monies. With regard to the solicitor's position, the matter is not completely without conjecture. However, arguably, the regulation of this aspect under the Legal Profession Act and what the solicitor is doing with the deposit monies pursuant to the provisions of the Legal Profession Act provide a firmer basis for the responsibilities being taken seriously, because of the consequences if they're not, in terms of how we understand the difference between whether the monies are held by agent as stakeholder or solicitor as stakeholder. So ultimately, even discounting self-interest, that saying the solicitor isn't necessarily the best preferred person, it may well be from a regulatory point of view that is the case. But again, we need to just be mindful of the changes to the regulatory environment for agents according to the POA 2014, and that may well be something to bear in mind, and also a question of practicality. So that, you know, I mean, it's all very well to talk about what's legally the more preferable outcome, but from a practical point of view, the client is often dealing with the agent in the first instance, not with a solicitor in the first instance. And, you know, it's more practically convenient for the agent, for the client buyer, to lodge the deposit with the agent. But we come then to really a balance of considerations between matters of convenience on the one hand and matters of security on the other, and where are these monies best held, and who's best to have charge and carriage of them. So, you know, there's different views there about that, but that's really what I was trying to get you to think about in the context of that important aspect of topic 2, with regard to how we understand the solicitor's role, and also advising the client in regard to us performing that role as stakeholder as opposed to an agent. And I think, you know, this is an aspect, and I've tried, the problem question tries to tease this out, that this is an aspect showing the practical, the importance of practical understanding, and what is practically useful, actually, at the end of the day for clients, and that we as practitioners need to appreciate that. We need to advise our clients not only with regard to legality and with regard to, you know, what the law requires and so on and so forth, and any changes and updates to the law and how that affects what's going on. But we do need to be ever mindful of providing practically useful advice to our clients. And also the other thing which is really important, I think, is to remember that we do not make those decisions for our clients. Okay, solicitors, legal practitioners continue to be legal advisors. They do not become the client. And sometimes some of our colleagues in the profession, I think, lose perspective on that difference, but that's something that's very important to be aware of, and that we are here in the land contract, in the conveyance process, to advise our client on the process and on the terms and conditions, on the clauses of the contract of sale, to shepherd our client through the process, which I think is a nice way to put it, in terms of the finalisation of the contract and of the transaction. But we are not the client, and we are not the entity that's involved in the transaction. So we need to be ever mindful of that as we progress through our studies in conveyancing. And yeah, so all right, well, I might leave it at that. Tonight's rather a short session. Nobody out there, but hopefully we'll get a few people next week. So next week we'll move on to topic 3. Okay, bye for now.